of lectures on compliance promoted by Ambra University, today we will have the presence of Professor Michael Hogan. Professor Michael Hogan is Chief Compliance Officer at Charles Schwab Investment Management, Managing Director at Charles Schwab and Company, and U.S. Attorney. Over 35 years of experience in the global financial industry in the areas of compliance, risk management, banking, and legal at companies such as Brown Brothers Harriman and Company, Wellington Management Company, LLP, and Charles Schwab. Juris Doctor from Suffolk University Law School, Master from Lindenwood University, and a Bachelor from Bates College. Holds the FINRA Series 7 license. The theme of today's lecture will be the liability and responsibility, aiming to address the responsibility of business leaders and top executives. Professor Hogan, good evening. It's such an honor to have you here tonight to make the presentation about liability and responsibility. You may have the word, please.
Thank you very much, Marcelo. I'm going to share my screen. Let's see, just all right. There we are. Okay. Well, thank you very much for that kind introduction, and it's my pleasure to be with you all tonight. As Marcelo indicated, I wanted to talk tonight about liability and responsibility. This is a theme that I think has become even more important in the compliance space than it has in the past. And that's for several reasons. The two most important being that courts and regulators are seeking to hold people responsible for what are considered to be compliance failures. I thought I'd break up the discussion today into a few points. First, I'll give a brief introduction. Then I want to talk about specifically designated officers. This is a trend that we've seen now in the United States and in other countries. The UK comes to mind, Ireland, Luxembourg, and the EU, where people are specifically designated as responsible for compliance. And there are a couple of distinctions we can see here. So part of this is to show several of the models, but also to maybe give a broader context to how compliance involves multiple layers of an organization. Then finally, I wanted to break down looking at a couple of specific language from some specific cases where people were held responsible. And we'll see what I'm talking about there, where it ranges from compliance people to business people to others. So we've seen that as a financial services regulation has evolved in the United States, and I think this can be said globally as well, concern was regularly raised about the responsibility of individuals for actions taken or not taken by organizations. So here we have this concept of a company, right? The company may have a recognition as a corporate entity, a legal person, if you will, but it is not a natural person. The company is made up of natural people, though. When a company makes a mistake, are people held responsible for it? Or, do we just say, well, we can't really hold companies liable because, they're not individuals? So that's kind of the notion that I wanted to highlight here. In the last 30 years, efforts to hold individuals responsible for corporate malfeasance and wrongdoing by corporations has increased. And there have been several high-profile instances. I list 3 of them here. There are clearly many, many more. So one that is very well known is the insider trading case against Michael Milliken in the late 1980s. There, he was held responsible for trading, on insider information in one of the most high-profile cases I'm aware of in that area. We talked about the accounting and Enron and its CEO Lay, who ultimately went to jail. So from an accounting standpoint, there is an expectation that individuals will be held responsible for mistakes. And then an example that happened earlier this year of market manipulation. The SEC, Securities and Exchange Commission here in the United States, charged Archegos, Juan, and Halligan with market manipulation and/or contributing to market manipulation. And just for a little context, Huang was the owner of the company, okay, and it's a family office, typically set up to manage a family's money. So he's the owner of the family office. But they charged Halligan, the chief compliance officer, the chief financial officer, as well as the chief risk officer and the head trader. So you can see that it's not just the people that caused the wrongdoing here, but it's extended beyond. Now, I point out this is just a charge. It hasn't been settled. It hasn't gone to court yet, but it's indicative of the environment we're in. Now, you probably have heard about the U.S. sentencing guidelines and the COSO, Committee on Sponsoring Organizations framework. They address this head on. They try to, establish responsibility for individuals in both, a regular individual setting, but also in a corporate setting to ensure that there's responsibility and liability appropriately for failures. But regardless of specific federally legislated requirements, and here I'm talking about the United States, but the same principle applies globally, fiduciary responsibilities of officers and directors of the corporations establish expectations of responsibility. So the people that are serving in officer level roles at the company and at director level roles, overseeing the entire company, will be held responsible for fiduciary duties to shareholders of the company. So that's another layer of responsibility that is important here. So let's talk a little now about some specifically designated officers. We've all probably heard the term Chief Compliance Officer. That's an example of a specifically designated officer, but you'll see shortly the Chief Executive Officer can also be a specifically designated officer. So the context for this is the idea that responsibilities for certain areas of regulatory compliance have fallen to certain named roles that are expected to be senior executives capable of influencing a firm's compliance efforts. Now, I emphasize that last point. These are not intended to be people who are given titles without power. They're expected to be people who are given titles that have power, and the people that fill those roles are expected to be people who can influence outcomes at the company. So we have two rules here in the United States, one applicable to investment advisors, investment management firms, and the other applicable to investment companies, what we typically call mutual funds here, or collective investment vehicles in other parts of the world. Now, both of these rules require the adoption of compliance program policies and procedures. So, the foundation for compliance programs, as we've talked about in prior discussions, as well as the appointment of a chief compliance officer who is responsible for administering them. So both rules set up the idea that the company, if you will, must have compliance programs and procedures, but there needs to be a person held responsible for administering them. It's not left up to a group. It's not left up to unknown people or junior people. It's the chief compliance officer. Now, the rules also require that that chief compliance officer do more than just administer policies and procedures. The CCO is required to conduct an annual review of these procedures, looking to ensure that they remain effective. Now, there's a slight difference here in the rules. The advisor rule does not require that the annual review be written, but generally speaking, it is written because you have to prove that you did it, and the only way to prove it is to put it in writing. But there is a distinction where the mutual fund rule, the collective investment vehicle rule, specifically requires that the CCO give a written annual report and that it be delivered to the board of directors of the mutual fund. So that's an example of where the compliance responsibility is clear. It's articulated in terms of responsibility and action, but it is also done in such a way that the report must go to the board of directors of the fund in order to give them a direct opportunity to inquire about the specifics of the report from the chief compliance officer. So this model is one where the compliance officer plays that primary role, certifies to the board about the role, okay, but ultimately is engaging with the board to the extent there may be problems or the board needs to get involved. It's up to the CCO to make that point, or to the board of directors members to inquire. There's a different rule applicable here in the United States to broker-dealers. So again, we're still in the financial services area. We've talked about advisors and mutual funds. Now we talk about broker-dealers, and you'll see that there's a pretty important distinction here. So these are FINRA rules 3130 and 3310. So rule 3130 requires the appointment of a CCO, so a chief compliance officer, as well as the written annual certification by the CEO. Now, the CCO typically provides information by way of a report to the CCO, but it's the CEO, the chief executive officer of the broker-dealer, that must certify annually that they maintain an effective compliance program. Very different, in my view, from the mutual fund model, where the board of directors receives a report from the CCO, but does not necessarily, is not required, at least by rule, to get anything from the chief executive of the investment advisor, for instance. Very, very different model, in my view, in terms of not just the requirements, but what the requirements mean. You know, in the broker-dealer space, the chief executive is ultimately signing the document and acknowledging that they have firsthand experience in understanding the firm's compliance efforts. FINRA also has a rule, Rule 3310, that requires the appointment of an individual. So interestingly here, it could be one or more people who are responsible for implementing and monitoring the anti-money laundering program. So this is a distinction. We've got a chief compliance officer generally for compliance, but we have an AML officer specifically for anti-money laundering related issues. So, you know, there's a slight difference there where it need not be the same individual. It certainly could be, depending on the organization and the choices it makes, but ultimately it is to make that determination. Now, more broadly in the United States, we have what's called the Bank Secrecy Act. And this requires the appointment of a Bank Secrecy Act officer with responsibility for overseeing the firm's BSA anti-money laundering compliance program. This is an important requirement, and it's one that banks and financial institutions in the United States have to meet, but I think it's also at this point standard across the world in any banking institution. Now, the reason these appointments are important, in my view, is number one, it identifies the person, who has these responsibilities, but it also allows a regulator to point to a specific person when there are problems. I'm aware of one example at a company I used to work for, Brown Brothers Harriman, where the bank they had a New York Stock Exchange member firm, so they were acting really more as a broker-dealer there, had received comments from FINRA during an exam on anti-money laundering, and ended up with the chief compliance, the chief AML officer there being held responsible for the firm's violations. So the fact that there's a person named makes it easier when there is a problem for the regulator to say, we want somebody to be responsible, and it could be any of these people. So those are some examples of specifically named people. What I want to do now, though, is talk very broadly about potential candidates for liability. These could include board members, management, the chief compliance officer, employees, and then we'll look at the language from the U.S. sentencing guidelines to see how broad this can be applied. But I do point you back to the example I cited at the very beginning of the Archegos capital management case, where multiple people, at all levels of the company were involved, including the chief risk officer. So we haven't talked much about chief risk officers because, in my experience, they tend to be more in what we call prudentially regulated institutions like banks, as opposed to the functional regulation by the SEC. In this particular instance, though, this was an SEC regulated entity, a capital management entity, which I believe was registered as an advisor, and they had a chief risk officer. It's that risk officer who was held responsible. Now, I ask you to bear with me because I've got a lot of language on the page here that I'm going to read for the most part. And this begins the, what I call kind of case studies, which are specific examples of where different people have been held liable. So here, we're talking about the board of directors of a company now. For context, Caremark claims, as they're called, are claims that directors breached the fiduciary duty of loyalty by not making a good faith effort to oversee the company's operations. So it's a term that is developed because of this Caremark case. So a case, being an adjudicated dispute, and directors were held responsible on that dispute for recognizing their fiduciary duty for failing to exercise on the duty of loyalty by not making a good faith effort to oversee the company's operations. So I think we have to keep in mind the board of directors typically is not responsible for management, but they are responsible for oversight, and which is why the language here is about overseeing and not, actually managing. Now, these claims are difficult to pursue because they require bad faith. Okay, so they did not make a good faith effort, the opposite being bad faith, which is intentional wrongdoing by the directors. So it's a very, very high standard for anybody to prove. But it does establish that with respect to a board's oversight obligation, only, and I'm quoting here the language from the case, sustained or systematic failure of the board to exercise oversight, such as an utter failure to attempt to assure a reasonable information and reporting system exists, will establish the lack of good faith that is a necessary condition to personal liability of directors. So ultimately, the directors of a company can be held liable personally for their failures. The standard is very high, but it is possible. So I think that, that's the important takeaway here. Directors take their roles typically very seriously. They want to ensure that they have an appropriate amount of information coming up to them to be able to exercise this duty of oversight. Now, reading from this bullet at the bottom, in addition to the growth restriction, the board's consent cease and desist order with Wells Fargo requires the firm to improve its governance and risk management processes, including strengthening the effectiveness of oversight by its board of directors. Until the firm makes sufficient improvements, it will be restricted from growing any larger than its total asset size as of the end of 2017. The board required each current director to sign the cease and desist order. So this is drawn from a cease and desist order that the Wells Fargo Bank Board of Directors had agreed to with the Federal Reserve. You can see that this is different from the Caremark claims because there's not necessarily a claim that they breached their fiduciary duty, but banking regulators have broad authorities. The fiduciary duty is a state law requirement, and so that's one way to go at board liability, but the other way is in a financial organization to do it by the regulatory authority of the Federal Reserve. That's what happened here. And as you see, the claim is that they did not have oversight processes that were effective. So we talk about compliance effectiveness a lot. Here, their oversight was not proven to be effective. And the requirement they had to pay was that they could not grow their assets. So the regulator effectively put a hold on growth by the bank until they fixed these problems. So from a board standpoint, to summarize, there are at least two potential impacts that we can draw from this. One is very difficult to prove, but that's one where the board of directors could face personal liability, each person specifically held responsible. The second is that the institution itself, the bank, can be restrained from growing until they fix the alleged problems. And importantly, the board required each director to sign the cease and desist, the Federal Reserve Board, that is. That's an important element that brings them in directly, individually, to the order itself. So there are at least two possible paths here from a board standpoint to establish liability. And the important takeaway is that the board must show that it is responsible for overseeing and that it has good processes to do so. Now I have an example here of management, and this is all publicly available information, so I'm not sharing anything that is confidential in all these instances. You can Google them and pull them up yourself. But this one is drawn from a situation my current company, Charles Schwab, faced back in 2010, I believe, 2010, 2011, where some of its practices with regards to investment management of mutual funds were called into question. Specifically, the chief investment officer, the person named Kim DeFotis, was held responsible here. And I'll read this for you. Through the knowing and reckless actions of DeFotis, the fund deviated from its concentration policy by at least early 2006 and violated the Investment Company Act by investing more than 25% of its assets in non-agency MBS without shareholder approval. So this is an example where there's a public company, the mutual fund, typically to make any significant change in investment policy requires approval by the the shareholders of the fund. They made a change. They determined that they did not have to get fund approval, but the market, fell apart, as we all know, and shareholders suffered losses. Whenever shareholders suffer losses, there's bound to be a lawsuit, and there's bound to be regulatory scrutiny on what happened. This particular gentleman, Kim DeFotis, was banned from the industry because of this. They had to pay, I believe, a monetary fine as well. So this is a clear example of management. He was not on the board, but he was management chief investment officer hired by the board to manage the assets of the fund. And he, ultimately was put in a position where, he basically lost his ability to engage in that career. Now I'll turn to another example of an individual being held responsible, and this is the chief compliance officer. So we've talked a lot about chief compliance officers earlier on. I set the context, if you will, by talking about the rules that investment advisors and mutual funds must follow. Well, this is a situation where the individual who was chief compliance officer at the investment management firm that the mutual fund hired was found to have been deficient in his responsibilities. He had to pay a fine, and they banned him from the industry. I don't think for life, but for a certain period of time. So reading here, the SEC order also finds that BlackRock and its then chief compliance officer, Bartholomew Batista, caused the fund's failure to report a material compliance matter, namely Rice's violation of BlackRock's investment policy to their boards of directors. BlackRock additionally failed to adopt and implement policies and procedures for outside activities of employees, and Batista caused this failure. And Batista agreed to pay a $60,000 penalty to settle the charges. So I highlight this for a few points. First, the order claims that Batista caused the funds not to meet a requirement, which is that the material compliance matter be reported to the board. So that's from the fund standpoint. So he is being held responsible for failing to report to the board. Additionally, BlackRock itself is being alleged to have failed to adopt policies and procedures, and that Batista caused that to happen. So you can see there, this is an example where the firm, the company, is alleged to have failed, BlackRock, but an individual is being held responsible for it. So keep that in mind. I began by saying, we see this trend where companies, may not be, or have historically maybe haven't been held liable, but in this particular instance, the person is being determined to have caused the failure of the company, and that person is paying. So this is considered to be a very significant case in the development of compliance practices here in the United States. Now, it's not just the board of directors, senior management, the chief compliance officer, but it's any employees of a company can be held responsible for failures. So in this particular case, as I have here, the Securities and Exchange Commission announced insider trading charges against 3 software engineers employed at Twilio Inc., a San Francisco-based cloud computing communications company, and 4 family members and friends. So we start with company employees, family members, and friends. Now we're outside of this corporate context, for allegedly generating more than $1 million in collective profits by insider trading ahead of the company's positive first quarter 2020 earnings announcement. So this goes beyond even what I began with in holding actions of people within the company responsible for their breaches, right? They misused information they garnered in the course of their work, but it also brought in family members and friends. So the employee, becomes the point of nexus, the contact between these individuals and the company, but ultimately it implicates them in the practice that allegedly, resulted in more than $1 million collectively gained by these people. So through these, you see there's a wide range of people who can be held responsible for compliance failures. And just to bring this to closure now, I would look to these U.S. sentencing guidelines. So these are guidelines that the Department of Justice has published to guide consideration of penalties against a company when a company is held to be, to have failed in compliance roles. The guidelines and policy statements in this chapter apply when the convicted defendant is an organization. So it's a criminal charge, defendant in a criminal case where they're convicted, and it's the company. Two factors that can mitigate the ultimate punishment of the organization are, one, the existence of an effective compliance and ethics program, and two, self-reporting, cooperation, or acceptance of responsibility. So I end with this to highlight that the effectiveness of a compliance program, but more importantly, a broad ethics program, right? We often talk of compliance, but I think compliance sometimes can bring us into a very narrow focus about compliance rules and regulations, where ultimately we're talking about ethical behavior on the part of employees. Nobody should think to, try to make money, by taking information they get at work and sharing it with their friends so that they can, privately benefit, at the expense of other sellers of the security. So that's an important element. And then, keeping the company itself and all of its management honest. Self-reporting, if you find an error, you should report it. Cooperate if the regulator's in looking at you, or if there's, Department of Justice doing or the Attorney General's office, doing an inquiry, cooperate with them, but ultimately accept responsibility where you see a failure. It's important guidance for corporations, certainly, which is what this is intended for, organizations. But it also, I think, is important for individuals who are faced with allegations. If you've done something, you really should, seek to take some responsibility. So I am happy to open up for discussion if you feel you want to. A couple of questions I have here are just suggestions. I can answer any questions, or we can engage in a dialogue on any point. But I'll just go through these first and then open up the floor. What are key lessons to be learned from each of these three readings? I've sort of highlighted what I see as key lessons along the way, but you may see that there are additional lessons here that may be important. The regulators in each were clearly suggesting that something else could have been done in each situation. What do you think Stump was the CEO of Wells Fargo Bank, and Batista, the CEO of BlackRock, should have done that they didn't, or should have done differently? And really, in this question, to me, is implicit this idea that it's very easy to look back at time to determine what we didn't do or should have done, because we know what happened. But when we don't know what's going to happen, it's really difficult to do that. There's a question of fairness, right? There are many people who feel that Batista, the CCO, should not have been held responsible here because business leaders made the decisions to do what they did. He could only control it to a certain degree. But that's an open question. On another question, do you think, based on the facts presented, that other parties may be responsible, at least in part, for these outcomes? We've seen in the more recent Archegos case that the SEC, cast a broad web in terms of who gets implicated. Maybe there are other people here. And then ultimately, one of the questions for us all is, do we think these outcomes are fair? Why or why not? Nothing is perfect in our world, as we know. We strive to do what's right. But, I would not want somebody to look at decisions I make today and apply, the benefit of hindsight and hold me responsible for something that was the best decision I could make at the time. That's the question, ultimately. And really, when we look at these particular instances, I think some people may conclude that that is not specifically what was encouraged here. It was really difficult to figure out whether somebody should have been held responsible, and regulators were overstepping. I'll pause now and invite anybody who has comments or questions to ask.
Well, Professor, I have two questions. And based on what you told us and based on American legislation, in addition to the occupants of management positions, is it possible to conclude that people in intermediate positions are accountable, right? So in this case, I'd like to know if the sanctions that these people are going to suffer, are going to be subjected to, are the same than those who occupy top executive positions.
I think that's a good question, but I'm not sure I have the answer to it, Marcelo. I think certainly in the most important examples, it is more senior people who are held responsible. I would suggest to you, though, that the case I mentioned earlier this year that has not been concluded yet, the Archegos case, is one that it would be interesting to follow. I don't think it's a very large family office, and it seems like almost everybody who was involved in the company, was charged there. Everybody doesn't have the same level of seniority necessarily, so that's one to look at. That said, I don't know all the facts and circumstances that the lawyers, and the attorney general would know, and maybe there is evidence to suggest that they were complicit in a crime. I don't know, that remains to be seen. I do think the one exception to what I just said, meaning it is clear that anybody can be charged regardless of your role, is insider trading. The people that were charged in the I forget the name of it. It'll come to me. But that were charged in the insider trading case I mentioned were not senior people. They were junior people. So Twilio is the name of the company. So those were junior people, and their family members and friends were also implicated. So anybody can be implicated for insider trading. In the corporate setting, I think for alleged failures by the company, it would really require that it be a senior person who could influence, right? Maybe they didn't, but they were in a position to influence. So, it really would depend on looking at if it's more corporate activity that's being questioned, then I think it's going to be more senior people. If it's less corporate activity and more individual activity, then, the spectrum shifts to the other side where it could be anybody if they're directly involved. Does that make sense?
Yes, that does make sense. And Professor, I have another question. Taking into account the sentencing guides, can a robust compliance program, even if it may have flaws, mitigate the responsibilities of the company's board of directors?
Well, I think that's an open question. Certainly, you must have a compliance program. We focused on whether the program is effective. I know I've talked about that in prior discussions. It is implicit and explicit in many of the rules, right? It's not just having a program, it's ensuring that the program is effective. The challenge with that model or that structure is that it's always easy, once a problem is identified, to say, oh, look, it wasn't effective, right? So, we call it the benefit of hindsight. I'm sure, there's a similar analogy in every language. But, if I knew yesterday what I knew today, I could have made different decisions yesterday, but I didn't know them. So as long as I'm making the decisions based on the quote unquote best available information to me, then I should be fine and I should be protected. From the director's responsibility level, though, and I think this is what the sentencing guidelines mention, the directors have to ensure that they have a good flow of information. That does not mean that they need to get everything, but it means that they have to have a mechanism for ensuring that the right information is funneled to them. And I know in the development of my board reporting, that's an important thing for my board, the board of directors of the mutual fund. Importantly, they don't want too much, because if you give them too much, then it's difficult for them to figure out what's really important and what isn't. On the other hand, they need to be sure, and they want a comfort level from me that they're getting the right information, okay? Now, I'm going to go back to the BlackRock case on this. So that case, as I mentioned, was about material compliance matters. The mutual fund rule, the investment company rule, requires that the board of directors be notified about material compliance matters. But it doesn't tell us exactly what is a material compliance matter. It doesn't define it. It leaves it to, in a sense, it leaves it to the board to say, well, this is what we think we need to know. That's a kind of difficult situation to be in, because now, we have to conform our behavior to what the board wants, but I also have to be sure that I'm giving them enough so that they could say, oh, we see a problem here. So, it's a challenge, no question. Very good question. Thank you.
All right. Does anyone else have any questions for Professor Michael Hogan? Professor Dalton, do you have any question?
I have one, but I'm waiting if another student wants to ask Michael directly. Anyone? So I think I will make a question. Michael, again, congratulations. It was an excellent presentation. I'm wondering here, in your point of view, how do you think chief compliance officers may be held responsible for third-party ventures or wrong conducts? What am I thinking here? In Brazil, we have a lot of enterprises that make contracts with third parties, and they don't make any responsibility for them. It's third-party problem, not ours. How, in your point of view, how it's a third-party contract, an exemption of, I don't know, do anything but outside my boundary, or I have to make some surveillance and be sometimes held responsible for this wrongdoing of our third-party companies?
Mm-hmm. It's a great question, Dalton. I'll answer in two ways. One, from the financial services perspective, but then I'll share just a broader perspective, since you said, how do I personally think of this? So from the financial services standpoint, our regulators here, and I think, again, this is a global thing, do not let us simply say, if it's outsourced to a third party, we don't have responsibility. At a minimum, we must have procedures to ensure that we conduct what we call due diligence on the company. So, I don't think there's a situation where we could ever say it's entirely outsourced, we're not responsible, if we can't show that we have done due diligence at the beginning and that we do it with some regularity afterwards. Maybe not every year, but every few years. So I think that's the answer in the financial services context. I think the question is very important today because we keep, well, almost everything we do in life now, right, involves some sort of third party. We're on Zoom right now. If we put inappropriate content here, Zoom could be held responsible. If photocopy machines were an example, where I think in the United States, at least, we had to adopt legislation that allowed people to photocopy because it was a violation of potential trademarks or other things. So, there's so much that the world we live in, with outsourcing, with tools, with electronics, can create by way of potential responsibility that, the question you raise is an important one. And I think in any industry, it's important to ensure that there is due diligence conducted on third parties, because you could find that there is a problem, and you will be embroiled in the mess one way or another. So it's better to have a defense that you have at least some basic procedures. Does that answer your question?
Yes, Michael, thank you. Marcelo, back to you.
Well, I think that anyone else has questions for Professor Michael Hogan. Professor, I'd like to thank you once again for sharing your knowledge with us. It was a great presentation, and we hope to see you again very soon. Well,
Marcelo,
this concludes another. Yes.
No, I was going to say thank you very much, and thank you all. I've really appreciated the opportunity to share some of my perspectives with you.
All right. Well, this concludes another lecture, and I would like to thank everyone who was able to dedicate some time of their time to the event. As well, I would like to thank Professor Dalton and the staff at Ambra University for the opportunity. Good night, everyone, and hope to see you all soon. Thank you.